the work has been done already. So at this stage, I thought that we expected the trial processes. Once this man is out of the box, KPMG will enter the box, give their testimony, their cross-examine, whatever their findings were, and the matter closes. But it means that they having to, do the work for the presiding judge. Obviously, means that the case is going to travel beyond the estimated time. That's the way I see it, because it means that that's another maybe a week or a week and a half work for KPMG to come and do. But the court has made the order. I mean,
The contention was as to whether Addison understood that in discussions in chambers, it was to include that, even though it was not on the formal order.
Yeah, what happened in chambers, I was not there.
You and I
cannot speak to what happened in chambers. Yes, if indeed it happened in chambers that there was a consensus ad idem that all parties had agreed that indeed the presiding judge thinks she should be made as part of the things to be audited but that was not part of the formal order.
But it was quite clear from how the rest of the justices were speaking that understanding was reached. That maybe it was not included.
That's why I'm saying that
order.
If that was so, I was not there. I was not in the chambers with them, so I can't speak to it. If it is so, then so be it. That's all I can say. But the order, a subsequent order now appears to be another work again for KPMG. But what is there for anybody to jubilate about this order? There's no jubilation about this particular order.
I don't think anybody has jubilated.
I saw this man.
Who is this man?
When we were on recess, giggling left and right and
but
all that.
They had always asked that even two additional justices' copies are audited in addition to those that had been done earlier. That was rejected though.
There's so much suspicion. So much suspicion in this particular trial.
But isn't that why you people are there? You suspect each other.
Suspicion. So much suspicion in this trial. But it's an order of the court that let's do another audit just to cross-check whatever has been done by KPMG on the one by the registry. So to me, what is there for anybody? Well, I mean, let them go and audit it.
Why
they go and audit it,
jubilating and if so, why?
They go and audit it. I mean, whatever it is, we will see the outcome of it.
Yes. George, why are you jubilating?
Thank you very much, Henry, and good afternoon once again to your viewers. I don't see why counsel is indicated I'm jubilating. He's been jubilating about objections this morning when it was, sustained for him, overruled. He had both. He had both, so he's happy. You see, Henry, I want to touch on the element of mischief. You see, when a lawyer is doing this to the bench, it's highly unacceptable. It's not too good for the profession. It becomes a black day for the judiciary, because lawyers are the first people the judges have to trust. The bench trusts the bar. So if somebody on the bar begins to play mischief and then the judge begins to send a signal, it's a bit problematic. And then more especially if it is a Supreme Court judge. You heard them. They went into chambers. There was a certain formal agreement, and that was with regard to our protestation that some number of boxes, there were some 24 boxes originally, became 31. 7 to 10 boxes thereabout have been added. And so we call for a different look at what is in the registry, because those boxes have been compromised. And then the control mechanism
allegedly.
So they went to chambers, the control mechanism was accepted. And at that meeting, Lawyer Addison was there. The order was made, but then the court did not formally put it into the order. But it was understandable that we are all living here with this consensus. Now you come to open court, and then you throw the same matter back to the judges, the justices, telling them that per what you have on your record, per the order, you don't see what they are talking about. But then counsel others have made it clear. You get to see that Lawyer Addison is just playing mischief. And you see, if you begin to play mischief in a trial, sensitive trial like this, it puts your credibility in doubt. In all this trial, throughout this trial, we've made it clear that the petitioners, their character or evidence or exhibits, don't let it go to character, but the exhibits in courts, it's not credible. Dr. Baumia was not credible with his evidence and testimony, and his lawyer is doing same. Even when you have met the law justices themselves, you have agreed on something, just for you to come back and say in the open court, the whole world is watching him. That, my lord, I think in the order, according to the order before me, it is not there.
But Justice Atuguba agreed. He admitted, yes, that he had not included that in his order.
And he proceeded to add that, regardless of that, we all left the meeting, the chamber, with the agreement that the presiding judge's copy will be added to what KPMG has already.
But that's a point to make. If it was agreed, but subsequent to that, your orders did not reflect that, and he's pointing that to you that your orders did not reflect that. So, as per what I've got here formally, work should be ending by now. Right now, do you want
I wouldn't want to.
That's a point to make.
I wouldn't want to belabor it, but then I want to let you understand that the use of that word mischief in the legal circles, in the judicial system, connotes a lot, and you can check it out. You can check it out from the Queen's language. It will be different, but when it comes to the judiciary, when it comes to lawyers, he's playing mischief, and he knows what it means by when he's playing mischief. You can't do that. You can't blatantly begin to doubt both your colleague at the bar and extend it to the justices. It's highly unacceptable, and he knows that. You can't do that.
You see,
Justice Bafuboni came in and said he's surprised that it is only he, Addison. He's the only person. It's so strange. And all this while Justice Bafuboni have been on this. Even when it's 8-1, it is Justice Bafuboni who is the one on Lawyer Addison's side. But today he's the one who has to pin him down and say that I'm surprised that you are the only person who has come out of the chamber and saying that he didn't know that this was a consensus agreement, an agreement that has been done. It's purely mischief.
Let's spend a little time.
You see, basically when my brother sits here and says that the SBs have been compromised, I don't know the basis upon which he makes that kind of assertion.
Yeah, allegedly.
Yes, you see, there were 24 boxes, now there are 31.
You made a definitive statement that they have been compromised.
That's our position.
On what basis are you making that kind of allegation?
I think that's even the basis for this order, isn't it?
For the presiding judge,
it's alleged. Let's not be too emphatic about it. That you think that they have been compromised. That's why.
No, hey, to set the record straight, you know this. There are petitioners we have responded. We, the respondents, are saying that is what we have seen.
It's an allegation that you are making.
Yes, of course, but we stand by it.
So yes, I mean it's an allegation. It remains an allegation.
Well, once you all agree that it's an allegation,
sure,
I think it should remain as such.
Okay.
But what you also have in court is allegation that statutory violations and then no overvoting. There are allegations.
That's why they are yet to be decided. So they remain allegations. Okay, I think that's where we're getting to. Let's just do some 5 minutes on what has transpired as far as the cross-examination is concerned between Addison. Okay, let's even go back to Chachu. Was quite brief, quite interesting.
Yes, and you realize that as I earlier on indicated that there's little that they were going to cross-examine Dr. Afarajan on. The reason is that they are all singing the same story. No irregularities. So obviously, if you see the way it was done, it was intended to confirm the story of the respondents. Basically, that's the way I saw it. Because there was no way they were going to throw any question which would seek to challenge the testimony given by Dr. Afarajan. But what they sought to do was just to, ask him questions which would confirm their story that indeed the elections to them were transparent. The election to them there were no problem. The election to them everything was fine, free and fair. Okay, that was what they sought to do. Now, you see, when it came to the cross-examination of Mr. Addison, Dr. Afarajan was trying to be evasive, and I'm telling him, you see, when you try to give evasive answers, you give yourself more problem. Go forward with the straightforward answers. I mean, if you ask a question yes or no, you answer the question either yes or no. If you need any explanation, you cannot add explanation. But try to attempt to give evasive answers, you will not be comfortable. And at the end of the day, today is just only a small show, I've told you from day one that this cross-examination is going to be a very hectic one for him. It's very simple if he decides to be, to be very honest and candid with the issues and the facts on the ground, to be straightforward with the facts on the ground. It's very simple. But the way he started now, trying to give evasive answers, I can assure you that tomorrow it is not going to be easy for him at all. Unless he comes back and come and change the style and decides to be very honest and frank with the court, and then we can all have a very easy going.
You would admit that he's also been quite tough. It's not been easy for Addison to get exactly what he wants from him.
No, you see, we just started the show. When you try to give evasive answers along the line, because it's being noted down, to come again to come and bite you. Today it's just a short one, only a few questions. This is just just warming up, just warming up the show. We haven't gone into the meat of the cross-examination in this matter. We haven't gone anywhere. Dr. Farijan will be put to so many things. I'm not saying you want to sit here to preempt or even tell you the information available to the petitioners. It's a lot of information. So when he denies them, then he will do his own statements. So after those ones, I don't see why it should be any difficulty at all. What I think you should go straight forward, be frank, be candid with the court, because don't forget that Afarijan has made so many public pronouncements, so many of them, and they are all caught on tapes, both video, audio, all over. So there's no point in coming to these elections and attempting to give evasive answers. You made a declaration. At the time you're making the declaration, what did you declare 26,002 polling stations? You see the answer you get, I believe that I did. Did you declare? It's a yes or no. Yes, I did. No, I did not. Then the explanation will follow. But I believe, you see, it's too early. It's too early, but I can assure you that if he wants to go the way that he want to go, he's going to face a lot of tough challenges, and that will be it. But if he wants to be candid, he wants to be frank, it's not. Because now the only thing left for him now is his credibility, that of the institution of the EC as an institution conducting public elections. If that is gone, if that is eroded, there's nothing left for them, and that is a very serious thing which I foresee happening. Okay. So he should do us a favor and an honor by just coming and be frank, be candid with the court, and everything will end quickly.
Okay, George, a bit on it.
Yeah, Harry, I think that like I said yesterday, I was not expecting lawyer Tony Later and then lawyer Chichikata to come and do much. The simple reason is that the witness, Dr. Farijan, just came to confirm our position, our case, and he landed very well in his examination in chief, stated those various 4 violations that they didn't exist. For example, serial numbers. What is his answer? They are not security features. They do not impact on the results that is down there on the pink sheet. Talk about voting without biometric registration. Everybody voted to the best of the EC's knowledge, the commission's position. Those who didn't get to vote, another day was made available for them on the 8th. About 400 polling stations, they went there, they voted. Issue of overvoting, there are excesses, 1 or 2 ballots they cannot invalidate. Unsigned pink sheets, presiding officer has made it clear. So he landed by saying that what he wanted the court to do is that the petitioners have not grounded enough evidence to even cause a rerun, let alone overturn the declaration. He's so sure, and that's the position of the EC. So let's come back to what Lawyer Chikata was supposed to do, to come and iron out and then just put it in perspective. He took him on IPAC meetings just to establish that political parties are stakeholders. They are key participants when it comes to the run of elections. Pre-electoral issues are all discussed at these IPAC meetings. And who go for IPAC meetings? Top hierarchies. You talk about chairman of the parties, talk about general secretaries, they are there. So for instance, this issue of no verification, no vote, you get to see that it was the MPP at one of the IPAC meeting who vociferously pushed it, that if somebody comes and the machine is not working, get a contingency plan, a backup machine. If it doesn't work, the person holds on until we get the person to vote. All these came out during the IPAC meeting. Lawyer Chikata wanted to make that clear. It would be in the minds of the justices that Dr. Farijan and the commission did not sit down and make these rules. They made it all the time along the way in conjunction with the parties. He also talked about meetings, 2 important briefings with top hierarchy of the parties, Akosomo and Accra. Some political parties decided not to represent, to go, and so they missed on some important information. And even when they have missed on, they didn't rely on other political parties to get those informations. All this Lawyer Chikata was trying to do to put the record straight that the election is a process. There are stakeholders, representative, party agent, all to come to the point that if the EC is even found wanting, if even the presiding officer, who is a temporary staff of the EC, is doing something untoward, is doing something which is not so clear by the law, you have a party representative, a candidate representative, you should be on top of issues and do whatever is supposed to be done. You look at applying infractions, that if there is to be any point of any infractions, it could go through, it will be applied throughout the country. And then if you come back to Lawyer Addison is just double standard. We keep to say that he's truncating my point. Double standard. If you see what Lawyer Addison is doing today, Harry, if viewers were watching the Supreme Court hearing proceedings today, the document on the BVD, you are seeking to block it from coming. Now you are using A1, pushing it to A1C,
which is not in evidence.
Which is not in evidence. Thank you very much. However, the information on A1 will be captured, transmitted to A1C, becomes your information. They tear apart. all those things basically. Now he ended up asking Dr. Afaijan that, so what information does the BVD operate? The doctor said, okay, it operates the details of the person going to vote, but it gives numbers. It tells you how many people have voted or something. So you don't want the information from the BVD to come to court. Now you are in court. Your first stance of examination.
But that's why their lawyers are there.
No, but it's double standard. It's always double standard.
No, I will not accept that. I think that's why the lawyers are there. So if there's any issue, they have to.
You see, that's the mischief. That's the mischief by the.
No, but when he had a problem, he was on his feet. He got the issue resolved.
I'm not sure if you got this.
I'm
you got my point right.
I'm getting
you are denying information
for us not to be like as if we're passing judgment here. Yes. That's why I'm saying this. That's why the lawyers are there. If they find any problem, they should object.
No, but that's exactly what my seniors Abdulaziz and Co be saying to the media today. That the petitioners are always putting up double standard. You see, one venue are seeking to block information from the biometric machine.
I think that it's a decision for the court.
No, this one is not a decision for the court.
State facts.
Double standard is not a decision for the court. Double standard is not. What we are saying is that from the proceedings, in one venue you seek to block information coming from the biometric verification device, the BVD for short, and then in your cross-examination, your first instance, you are putting the witness under intense disposition as to what goes to A1 and then transmitted to the. It's all about the BVD.
But it's double standards. The judges will have to decide.
It's double standards.
I will pray that you will expunge the last part of the submission of the record.
A mark R, eh?
Mark it as rejected. You know, because the EC is being represented by capable hands. Okay. You understand? These are competent lawyers.
We are also representing here in the studio to do the commentary.
Who are doing a very good job.
We are representing the EC to do the commentary.
So I mean, it does not lie in your mouth to make those kind of statements. So please, expand that part of the record and mark it as rejected.
Double standard is always up there.
Henry, exhibit what?
TV3. And then mark it reject, because that portion to be rejected from the record.
Thanks a lot for joining us. George Tete. I got it right? Tete Wayo. Forgive me. Why? After so many days, George Tete Wayo speaks for the NDC. We're grateful for your time. A legal practitioner, just to be precise. Also, Gary Nima Kumafu speaks for the NPP. Also a legal practitioner. So I've had two legal persons here and they've helped us. Today, Dr. Ampawa was not with us. Possibly tomorrow he joins us and we'll get a full house. We can have our discussions. And we'll meet again when the court assembles, comes back from its adjournment. We'll understand a lot more of what's happening or what is to happen. We'll know a lot more about this KPMG issue. I think it's being pronounced on now. It's over. So the cross-examination will continue. Dr. Afarijan will get into that witness box. We'll see Lawyer Addison back on his feet again, and the other lawyers for sure very, very much alert to ensure he doesn't slip something through. Today, something almost went through, but for the vigilance of Addison, Addison. That's why he's paid to be there, isn't it?
Yes.
Okay, so let's see how it goes tomorrow, which other documents comes through, but it's all a game, and if you're not fast enough, then that's it. If you are sat down, well,
no, but Henry, it must not be mischievous. When he was caught along the line, he said he was using it for the witness to refresh his memory.
I was talking about something else, about the first one that was rejected.
That's
what I was talking about.
Now he's happy about it.
Thanks again. We're grateful for your time. Those of you on the other side who've helped with discussion, a few of you have been sending your text messages. They fed into what we're doing. We're grateful. We're grateful to know that you're also listening, watching, and reasoning alongside. Let's keep this debate on. Let's be calm. Let's pray for our Supreme Court judges. And I think for my panelists here as well, to still strong, come and help us with their objective views. I'm Henry Herbert Mam on behalf of the crew here. We say we're grateful for your time and continue enjoying and watching TV3.